Okay, so we're gonna get the corporations committee started. Really appreciate everybody kind of joining us in these weird times. Wish we all could be together down in, well, I think we were originally planning on doing this up somewhere in my neck of the woods, but not this time, unfortunately. So we're gonna get started, and I guess the first order of business, let's go ahead and call the roll.
Senator Case.
Excuse.
Senator Nethercott.
Here.
Senator Schuler.
Here.
Senator Scott.
Here.
Representative Blackburn.
Here.
Representative Clausen.
Here.
Representative Clem.
Here.
Representative Clifford.
Here.
Representative Duncan.
Here.
Representative Edwards. Representative Edwards.
Here.
Representative Ayer.
Here.
Representative Furphy.
We'll call him excused for now. He was there.
Co-Chairman Landon.
Here.
Chairman Lindholm.
Here. All right, perfect. We have quorum. Once again, really appreciate everybody jumping on to the Zoom call, and for all of the public out there, really appreciate your participation. We're going to start off things. As a committee, I'll note we got several topics added to our normal list from Management Council, and those are COVID related topics, and some of them are definitely kind of outside of the norm for the Corporations Committee, relating to public health and what have you. So, and then we'll probably, for the committee's knowledge, we're probably looking at having another Corporations Committee meeting in the next couple of weeks if the Broadband Task Force completes their legislation, and for the purpose of sending that forward to the special session. So with that, Mr. Co-Chairman, did you want to say anything real quick before we get started on the agenda?
Mr. Co-Chairman, thank you. You covered a couple of the things I was going to outline. Obviously, we have some additional items to cover today, so it's going to be a busy day. I too regret that we can't be together because I miss all of you guys. Look forward to the day that we can have one of our real meetings. But in place of that, we'll do the best we can with this format, and hopefully we did allow in some late folks who wanted to testify and simply didn't know how to navigate the system. And so I think it should be a great day, and appreciate you chairing today. Mr. Chairman, take it away.
All right, thank you, Mr. Chairman. All right, so we're going to get started with the Department of Insurance, and we've got Commissioner Rood and his deputy, Deputy Johnson, that are going to present to us. So Commissioner Rood, go ahead, please. I don't know if you're presenting yet, Commissioner, but we can't hear you. Still nothing.
Can you hear me now?
Yes, sir. Yep.
Oh, much better. Thank you. Appreciate it, Mr. Chairman, committee members. Commissioner Jeff Rood with Department of Insurance, and along with me is Ms. Johnson, the Deputy Commissioner. I understand you have a full agenda today, so we'll try to be succinct with it. We plan to cover two topics. We were going to look at amendments for the Credit for Reinsurance Model Act, which Ms. Johnson will get to here shortly. The second topic, we're going to review the CE rules and looking for a potential way to outsource the CE function to a third party. Unfortunately, this, with regards to the continuing education, that has actually taken longer for us than we originally planned. Given COVID-19 and with the testing facilities shutting down and them having to swing their attention towards trying to do it virtually, we're not as far along with that as we would like. So the long and short of it is we do not have a bill for you today. If it's all right with the committee, we'll plan on continue to work that. If we can get a draft to you by the next meeting, we'll bring it. If not, we'll just hold on to it for another time. But unless there's any questions with that, we'll go right into the credit for reinsurance amendments with Ms. Johnson.
Any questions, committee, about delaying one piece of insurance legislation?
No.
Seeing none. All right, Commissioner or Deputy, please.
Okay, thank you, Mr. Chairman. My name is Linda Johnson. I'm the Deputy Commissioner for the Wyoming Insurance Department. And the bill you have in front of you updates Chapter 5 of the Insurance Code, which relates to credit for reinsurance. And this is a model that we've had on the books for a long time. We last updated it in 2017, and now we need to update it again due to international developments and also to avoid federal preemption. In addition, this model is also an NAIC accreditation standard as well. As a little background for this topic, first of all, I just wanted to explain what reinsurance is. Reinsurance is insurance for insurance companies. So you and I as policyholders don't deal with reinsurance. This is something that takes place in the background without the policyholder's knowledge. But it's basically an insurance company passing off some of its risks to another company called a reinsurer. And so it allows the insurance company to reduce the liabilities it reports on its balance sheet because it's ceding off some of the risk to a reinsurer or multiple reinsurers that meet certain requirements that are outlined in Chapter 5. So the reinsurance framework that we currently have in Chapter 5 provides 6 different ways that a domestic insurance company can reduce its liabilities on its balance sheet by using reinsurance. So this bill adds a 7th way that the domestic insurer can reduce its liabilities by utilizing reinsurance, and provided those reinsurers meet certain requirements. As a little history, in the past, we used to require offshore reinsurers to post 100% collateral for any liabilities that they assumed from U.S. insurance companies. And this became an international trade issue because a lot of the world's largest reinsurers are across the Atlantic. So your Lloyd's of London, Swiss Re, Munich Re, those companies. So back in January and February of 2017, we updated our law to allow these offshore reinsurers to reduce the collateral that they had to post based on their certified reinsurer status and whether or not they were domiciled in a qualified jurisdiction. So therefore, these offshore reinsurers that became certified reinsurers were able to post reduced collateral. So maybe they only had to post 20% or 50% as opposed to the 100% that they used to. So we updated our law in January and February for that certified reinsurer and qualified jurisdiction implementation. But then in September of 2017, so later that year, the U.S. Trade Representative signed a covered agreement with the European Union, which eliminated all collateral requirements for EU companies, provided that they met certain requirements. And then in December of 2018, the U.S. Trade Representative signed a similar agreement with the UK,
Hang on a sec real quick, Deputy. Mr. Chairman.
Madam Deputy Commissioner, I apologize, but I need to have the staff let Senator Case into the room, if you would, please.
Oh, okay.
Thank you very much.
Okay.
I might actually be able to do that. Representative Furphy is trying to join again. I'm not seeing Senator Case in the waiting room.
Mr. Chairman, there he is. Okay.
Yep. And Representative Edwards, do you have a question? No. Okay. Ms. Deputy, please continue.
Okay, thank you, Mr. Chairman. So based on these covered agreements that were signed with the U.S. Trade Representative, with the EU, the European Union, and the UK, state insurance regulators basically have 5 years from the date of the covered agreements, which the first one with the EU was in September of 2017. So we have 5 years from that date to come into compliance with the terms of those agreements, or else we'll face federal preemption beginning in September of 2022. So that's why we have another update to this law in order to avoid federal preemption. So just to kind of reiterate, back in 2017, we introduced the concept of certified reinsurers in qualified jurisdictions. And with this update, we're introducing the concept of reciprocal jurisdictions, which includes those countries that the U.S. has a signed covered agreement with, so like the EU and the UK. So with that little bit of background, I can jump into the bill if that's okay.
Yeah, please go ahead.
Okay. So again, this bill is titled Credit for Reinsurance, and if you look on page 1, section 1 begins on line 9, and what we're doing is we're adding a couple of new paragraphs in section 1. So if you go over to page 2, on line 2, section 112, we're updating this section to include Roman numeral 7 on line 22. And so this again is adding a 7th way to allow a ceding insurer to take credit for reinsurance. And so they can do that when the reinsurance is ceded to an assuming insurer. And if you go over to page 3, that assuming insurer has its head office or is domiciled in a reciprocal jurisdiction as applicable and is licensed in a reciprocal jurisdiction. And we define reciprocal jurisdictions later in the bill on page 12. But just to reiterate, a reciprocal jurisdiction includes those jurisdictions that the U.S. has a signed agreement with, so like the EU and the UK. So on line 6, it says the assuming insurer has and maintains minimum capital and surplus specified in rules adopted by the commissioner. So along with this bill, if this passes, we would also need to update our regulation chapter 50 that goes along with this model act. And just to give you a heads up of what's in that model, the minimum capital and surplus that's required is $250 million. So again, these are your large reinsurance companies. And then on line 19, it says the assuming insurer, which again is also the reinsurer, another term for that, has and maintains a minimum solvency or capital ratio as specified in rules adopted by the commissioner. And this would be, again, in our updated chapter 50 that we'll need to do. And we'll be looking at a minimum capital ratio of 300% risk-based capital or another company's capital ratio as well. And if you go over to page 4, on line 6, the assuming insurer has to agree in writing to the 5 following requirements. And again, these requirements will be specified in rules. There's a form RJ-1 in the model regulation that we would need to adopt that spells out these 5 requirements that will need to be in writing. So on line 10, the first item that will need to be in writing is that the assuming insurer shall provide prompt written notice to the commissioner if it falls below the minimum capitalization requirements or if any regulatory action is taken for material non-compliance. And then on line 17, the assuming insurer shall also consent in writing to the jurisdiction of the courts of this state and to the appointment of the commissioner as agent for service of process. And then if you go over to page 5, the third item, the assuming insurer shall consent in writing to pay all final judgments wherever enforcement is sought obtained by a ceding insurer. And then the fourth item on line 12 is that each reinsurance agreement shall require the assuming insurer to provide security equal to 100% of the assuming insurer's liabilities if the assuming insurer resists enforcement of a final action. And then the final item that needs to be in writing on page 6, line 1, is that the assuming insurer shall confirm that it is not presently participating in any solvent scheme of arrangement which involves this state's ceding insurers. And if they do, they have to provide 100% security of the liabilities to the ceding insurer. And the solvent scheme of arrangement is a mechanism that's used in the UK. And so it's not beneficial to policyholders. So that's why we would require 100% security for any of those liabilities if a solvent scheme of arrangement was in place. So those are the 5 items that need to be confirmed in writing. And then additional requirements for the assuming insurer, starting on line 13 of page 6, is that the assuming insurer shall provide documentation to the commissioner as specified in rule. And then on line 19, the assuming insurer shall maintain a practice of prompt payment of claims under its reinsurance agreements. And then on page 7, line 1, The assuming insurer's supervisory authority or regulator shall confirm to the commissioner on an annual basis that the assuming insurer complies with the capitalization requirements that we noted on page 1 of the bill. And then on line 9, it says an assuming insurer can provide information on a voluntary basis. And then on line 13, it says that the commissioner shall timely create and publish a list of reciprocal jurisdictions. So we already maintain a list of qualified jurisdictions on our website. So with this bill, we would need to add a list of reciprocal jurisdictions as well. And then if you go over to page 8, line 13, says the commissioner shall timely create and publish a list of assuming insurers that have satisfied all conditions and to which cessions shall be granted credit. And this will be similar to the list of certified reinsurers that we have on our website. So again, we would add this to the list of companies or reinsurance companies on our website as well. If you go over to page 9, line 4, it says, if the commissioner determines that an assuming insurer no longer meets one or more of the requirements, the commissioner may revoke or suspend the eligibility of the assuming insurer as set forth in rules. And then going over to page 10, line 2, it says, if subject to rehabilitation, liquidation, or conservation, the ceding insurer may obtain an order requiring that the assuming insurer post security for all outstanding ceded liabilities. And then the paragraph starting on line 9 basically says that the parties can agree to other terms in their reinsurance agreements that are not not expressly prohibited in statute. And on line 15 of page 10, it says credit may be taken under this paragraph only for reinsurance agreements entered into, amended, or renewed on or after July 1, 2021, which is the proposed effective date of this legislation. And it's provided that the assuming insurer has met all of the eligibility requirements. And so again, that would be the minimum capitalization requirement and compliance with the capital ratio. So if you go over to page 11, on line 5, this paragraph says that an assuming insurer can only withdraw or reduce its security provided under the terms of the reinsurance agreement. So again, it's only as permitted under the reinsurance agreement that an assuming insurer could reduce any security that's provided for collateral. On line 10, this paragraph says that the parties can renegotiate their reinsurance agreements. And then on line 16, we're adding some definitions here. And so we're defining covered agreement, which means an agreement entered into pursuant to the Dodd-Frank Act, and that addresses the elimination under specified conditions of collateral requirements. And so again, these are the two agreements that the US has with the EU and the UK at this time. And if you go over to page 12, we're defining reciprocal jurisdiction on line 4. And there are several ways to be a reciprocal jurisdiction. On line 7, you can be a non-United States jurisdiction that is subject to an in-force covered agreement with the United States, again, the EU and the UK. Or on line 13, a reciprocal jurisdiction can be a United States jurisdiction that meets the requirements for accreditation. Or on line 17, it can be a qualified jurisdiction, which is, again, what we implemented during the 2017 session. So it can be a qualified jurisdiction that meets certain additional requirements consistent with the terms of the covered agreement. So if you go over to page 13, we're updating section 116 here on line 2. And on letter F on line 4, it says a regulation adopted pursuant to subsection C of this section shall not apply to cessions to an assuming insurer that meets the conditions that we're updating here in this bill. And subsection C refers to captive reinsurance, which companies that meet these requirements in this bill would not be captive reinsurers. So the companies that we're talking about in this bill are what we consider professional reinsurers. So they are exempt from having to meet those requirements in subsection C of the regulations. So we're just spelling that out, that any reinsurers that meet the conditions in this bill would not have to comply with the subsection C in our existing rules. And then on line 16 and line 21, we're just renumbering existing language here. And then on the last page, page 14 of the bill, line 5, section 2, it says this act is effective July 1, 2021. And again, we would be preempted starting in September of 2022 if we didn't have this legislation in place. So we do have the effective date, July 1, 2021, which would meet that requirement before September 2022. I also have a proposed amendment if I just wanted to give you a heads up about that as well. So are there any questions?
Yeah, go ahead and cover the amendment really quick, please, Deputy.
Okay. So if you go to page 14, it's a real short amendment. Let me get there. Or sorry, not page 4. Page 4, line 14. Sorry about that. So on line 14, the last word in that line is the word material. The word that was used in the model was the word serious. And I know material seems to make more sense to us in the US, but the word serious is what is actually used in the covered agreement. And so when I ran this draft by the NEIC legal staff, they strongly suggested that we put the word serious back in there in place of the word material, because apparently that is what the international community preferred when they were negotiating the agreement. So just to avoid any interpretation issues down the road, they strongly suggest we stick with the model language because it's important that we're all kind of on the same page. I know that's one issue that other countries have with the US regulatory system for insurance is that they're dealing with over 50 different jurisdictions instead of just one regulator. So they've expressed, concern that we try to stay as closely to the model as possible just to avoid any interpretation issues between the states. So that's the amendment, to change the word from material to serious, which matches the model language.
Gotcha. And
Okay.
just real quick, Deputy, this legislation is, and I believe you stated it several times, it is an NAIC accreditation issue. And if we don't do this, we risk the feds coming in and regulating insurance in the state of Wyoming. Is that correct?
Mr. Chairman, that's correct. And this particular, the reason why we would face federal preemption in this issue is that the U.S. trade representative signed an agreement with these other countries. And so if we don't get our laws in compliance with those trade agreements, we will be federally preempted in this particular area. So.
Gotcha. Chairman Landon, go ahead.
Thank you, Mr. Co-Chairman. And Deputy Commissioner, I really appreciate having you here because we really need somebody with a depth of understanding in all of this. I actually had a check mark beside line 14 on page 4, and you have mostly answered my question, but the second part of my question would be what would be considered a serious non-compliance, for example? And I assume that could be another country that has assessed some sort of requirement on assuming insurer, or how does that work?
Deputy, go ahead.
Okay, Mr. Chairman, that's correct. So just as an example, if a company did not follow a country's law and it was a serious law, say, and it doesn't necessarily have to be a financial issue. So like in the US, in order for somebody to be allowed to work in the insurance industry, if they have committed a felony that say they've embezzled funds or something, they have to get permission to work in the insurance industry. So, if you find out that a company's CEO, previously embezzled money from another company or something like that, and they didn't file that 1033 and get that 1033 waiver to work in the insurance industry, that would be something that could be, serious non-compliance issue that doesn't necessarily involve, monetary damage if he hasn't stole money from the current company, something like that. So does that?
Thank you.
Okay.
Any follow-up? Any other questions, committee? For the Representative Furphy, go ahead.
Thank you, Mr. Chairman. By the way, I was here at the start of the meeting. I got booted off the system for some reason. Yeah. I have two simple questions. On page 5, where it talks about providing security, give me sort of a definition of what would be appropriate security to assume their liabilities.
Deputy, go ahead.
Mr. Chairman, that could be cash, a letter of credit, just in any form of, like, say, basically cash, a trust account, that kind of thing. So.
Any follow-up, Representative Furphy?
Well, when you say a trust account, I'm a little concerned about that. What does that mean?
Deputy?
Mr. Chairman, there's certain requirements for what assets can be used in those trust accounts. So you'd want to make sure that it's has the appropriate market value to cover the liabilities. And so, cash, treasuries, that kind of thing. And I'm looking in the law here, sorry. And it actually might be in the regulation.
Mr. Chairman, so mostly you're saying cash, but yeah, I was concerned an insurance company offering trust accounts. Anyway, we can look that up. My second question, Mr. Chairman, is on page 7, where it talks about supervisory authority has to provide the capital of these firms on an annual basis. I'm just curious, if all of a sudden they report that they are not meeting the capital requirements, what action do you take, and what do we do to protect our citizens?
Deputy, go ahead.
Okay, thank you, Mr. Chairman. Just to clarify on that one issue, the insurance company would set up a trust through a financial institution, and then that would be reviewed by the domestic regulator. So it wouldn't actually be the insurance company holding the trust. It would be set up at a financial institution. So I did just want to clarify that. And on the next issue where you said if the assuming insurer falls below the capital requirements and the supervisory authority reports that to us, then we could revoke that assuming insurer's authority to not have to post collateral. So we could basically remove them from being, well, it would penalize the domestic insurer. They would not be able to take credit for any liability ceded to that assuming reinsurer unless they posted the 100% collateral, because their status would have been revoked. So they would have to go back to posting 100% collateral if they fell below the minimum capital requirements.
Thank you.
Any other questions for the deputy? Not seeing anybody jumping. All right. Ella, so do we have any public comment on this topic? Actually, I should ask first, Deputy, is there anything else that you have to present?
Mr. Chairman, no, just that amendment. So, yeah.
Okay.
Yep.
I did not have anyone on the list to provide public comment on this.
Okay, great. All right, so we have no public comment. Committee, I'm going to go ahead and what's your pleasure on this legislation?
I would move the bill, Mr. Chairman.
Okay, that was moved by Chairman Landon, second by Representative Duncan. Any amendments? There is a proposed amendment from the Department of Insurance.
Mr. Chairman, I'll move the amendment by the Department of Insurance.
Okay, that's moved by Representative Duncan. Is there a second?
I'll second it.
Second by Senator Schuler. Any discussion on the proposed amendment? Yeah, Senator Scott, go ahead.
Mr. Chairman, quick question from the department. Is the word serious defined elsewhere in international law, or is it defined by court precedent? How do we know what it means?
Deputy.
Mr. Chairman, I'm not sure if it's defined in international law. I know when I talked to the NEIC, they said that when they were negotiating the agreement, that the U.S. did try to use the word material, but the international community wanted the word serious. And so I assume maybe that is more of a defined term in the international community, but I don't know what that definition is.
Good question.
And I can check with the NEIC legal staff on that.
Senator Scott, go ahead.
Mr. Chairman, I think we will need to know that before we actually take it to the floor. So if the department could research how that's defined, it may well be that it's been used enough. There's lots of precedent on it. But I think we need to be prepared for that particular question.
Okay.
Any further discussion in regards to the proposed amendment? I guess the question that I would have, or maybe this is for you, Chairman Landon, technically this piece of legislation is essentially ready to go. The only question I've got is whether or not this amendment would kind of slow it down, or at least move it to another meeting where we're going to have to revisit. Not that I'm against revisiting the legislation, it's just that, do we need to?
Mr. Chairman, I appreciate your thoughts. I guess I would be inclined to put this forward. If the committee chooses to adopt the bill, I think we send it forward to the next session and be done with credit for reinsurance.
Yeah, no, I'm in agreement. And so before we have to vote on this proposed amendment, I'm going to ask the deputy to report to, if this is okay with Senator Scott and everybody else on the committee, to report back to the chairman on the definition of serious and find out any negative consequences that there could be in regards to that language. And then that way, if we need to pull that language out during committee in session, we can certainly do that. Would that be acceptable to you, Senator Scott?
Yes, Mr. Chairman, and frankly, I think as long as we have it by the first committee meeting in the general session, I think this is aimed at the general session. That's I think satisfactory. I think we just have to be prepared. I think there's a good answer.
Great. Any other?
Oh,
go ahead.
Mr. Chairman, I can possibly get an answer to you by the end of today. The NEIC legal staff has been very responsive, so I can call him today and maybe email you this afternoon, so you can have it maybe before the end of your meeting today, if that would be okay.
That'd be great. Yeah, please do that, Deputy.
I'll try to get in touch. Yep.
Okay. So the question on the table is in regards to the proposed amendment to strike the word material and insert serious. Is there any other discussion on the amendment? Seeing none, all those in favor, please raise your hand. All those against, please raise your hand. Amendment carries. All right, we're back on the bill. Any other discussion or comments, amendments, anything like that on the proposed legislation? Seeing none. And members, this will be a final vote for, so we're going to be doing a roll call on this to send this forward to the general session in 2021. So with that, LSO, please call the roll.
Will do, Mr. Chairman. Just one point of clarification on this bill draft. It is labeled CC Draft A, and that is because we have one drafting system, and we currently have that set up to be used for the special session bills. And as this bill draft is for the general session, we couldn't use that drafting system. So once we create the new drafting system, we will give this a 21 LSO number. How you can see it going forward once we get that system set. And so with that, we'll call the roll. Senator Case.
Aye.
Senator Nethercott.
Aye.
Senator Schuler.
Aye.
Senator Scott.
Aye.
Representative Blackburn.
Aye.
Representative Clausen.
Aye.
Representative Clem.
No.
Representative Clifford.
Aye.
Representative Duncan.
Aye.
Representative Edwards.
No.
Representative Ayer.
Aye.
Representative Furphy.
Aye.
Co-Chairman Landon.
Aye.
Chairman Lindholm.
Aye.
Mr. Chairman, would you like to assign that to the House or the Senate at this point, or would you like to make that determination later?
Yeah, let's make that later, I think. Don't you think, Mr. Chairman?
I agree, Mr. Chairman. We can visit about that at a later date.
Everybody loves these nice, long NAIC insurance bills. This sounds like a Representative Ayer presentation to me. He's kind of our bulldog on the floor. Nobody messes with him. All right, committee, we're clipping along at a breakneck pace, doing really good. We're actually ahead of time by quite a bit. So I'm going to go ahead and we'll open up the next section, which is liquor licenses. I have a feeling this will slow us down, so it's good that we made a little extra time for it. To the Deputy Commissioner and Commissioner, thank you very much for your presentation and your work in this regard for the state. So we're going to get into liquor licenses, and we're going to be doing a review of liquor licenses and permits, first from LSO. Is that you leading that, Mr. Hewitt?
Yes, yeah, thank you, Mr. Chairman. So the LSO was asked to take a look at the provisions within Title 12 that govern liquor licenses and permits. And I put together a memo for the committee on this. It was included in the committee's materials. It's titled Alcoholic and Malt Beverage Sales, Licensing and Permitting. And it provides a high-level summary of the licenses and permits in statute that local authorities can issue to businesses so that they can lawfully sell alcoholic beverages. So, Mr. Chairman, if it's okay with you, I'll just run through the memo real quick.
Yes, please.
All right. So on page 1 of the memo, it starts out with just a brief discussion of the authority of cities, towns, and counties to issue these licenses and permits. They can choose to do so. They don't have to. And then moving on to the retail liquor licenses and malt beverage permits on page 1. Retail liquor licenses are the broadest of the liquor licenses in statute. They are based on population, and you can see the population formula at the bottom of page 1. The larger the town gets, the more liquor licenses can be issued by the city. There's also a formula for unincorporated areas of a county with respect to what or how many liquor licenses can be issued. And that formula is at the top of page 2. Counties can also issue malt beverage permits for the sale of malt beverages, and those can be issued without regard to population. And then on the first full paragraph on page 2, you can see the fee schedule for retail liquor licenses and malt beverage permits. Next on page 2, we get into special club licenses under 124301. And this provision provides that certain social clubs can receive licenses to sell alcoholic beverages for consumption on the premises of the social club. Permissible clubs are listed and include veterans groups, fraternal organizations, golf clubs, and tax-exempt social clubs. College fraternities and labor unions do not qualify. Next, resorts.
Hey, Mr. Hewitt, I'm going to jump in real quick there. Is there any limitation on the number of special club licenses a municipality or political subdivision may issue?
I don't believe so, Mr. Chairman.
Okay.
Yeah.
Thank you. Please continue.
All right. So with respect to resort liquor licenses, resorts that meet certain conditions can receive a permit to sell alcoholic beverages on the premises of the resort. Next, restaurant liquor licenses under 124407 through 124411 provide that restaurants can issue.
Mr. Chairman, real quick.
Yeah, go ahead.
I'm sorry to interrupt and go back, Ted. On the social club question, is with a social club, can you have, would a person be able to have children in their establishment?
Mr. Chairman, Representative Duncan, I'm not sure. I don't know of a specific prohibition on that.
I think our normal Wyoming laws would apply. So at that point, yeah, as long as they're with a parent.
As long as they're with a parent? Okay.
Mr. Chairman?
Yeah, go ahead, Senator Case.
Mr. Chairman, I think typically it's a local licensing authority that dials that in. They may allow children in a part of the facility and not in another part. You all know I'm a liquor license holder, and we're not allowed to have children within at the bar properly, but children can be elsewhere, and it's a local license thing.
So like at a table with the parent, but not at the stand up at the bar with the bartender.
Mr. Chairman, that's correct in that particular instance, but there are various restaurants in town, and they have different requirements within their area specified by the local license authority, which is the city council.
Thank you.
That's great information. Thank you, Senator Case. Mr. Hewitt, please continue.
All right, so we're on restaurant liquor licenses, and these licenses allow the sale of alcoholic beverages for consumption on the premises of a restaurant, with the exception that a patron can take a partially consumed bottle of wine off the premises of the restaurant if it was purchased with a meal. Drinks have to be prepared in a room separate from a dining area, and a restaurant has to show that at least 60% of its gross sales are derived from food service. On to page 3, we get into bar and grill liquor licenses. And these are very similar to restaurant liquor licenses. The differences are that drinks need not be prepared in a room separate from the dining area. And the fees for these licenses can go up to $10,500 annually, which is more than the maximum fee for a restaurant liquor license of $3,000 annually. Additionally, there are population limits on bar and grill licenses, and you can see that formula on page 3 in the bullet points. Next, microbrewery and winery permits are governed by 124412. And under these permits, these entities can sell their products directly to consumers. These permits are limited in number to the number of retail liquor licenses allowed under the population formula for cities and towns. Winery permit holders can get permits for satellite locations, and wineries can also ship wine directly to households in Wyoming under certain conditions. For microbreweries, the legislature passed a law in this past session to allow multiple locations of a microbrewery within one jurisdiction to count as one location. And there's an associated fee with having additional brewery locations within one jurisdiction. On page 4, we get into how rectifiers and distillers of liquors can dispense their products. They may dispense their products, they may dispense samples of their products directly to consumers under certain conditions. They can receive a permit to sell their products at a satellite location, and they can get a 24-hour permit to sell their product at meetings, conventions, private parties, dinner gatherings, and other similar gatherings. And then the Wyoming statutes have a series of special permits for malt beverages or other alcoholic beverages. I've got them listed on page 4. There's one specifically for the student union at the University of Wyoming. That's for kegs of beer. There are 24-hour malt beverage permits for picnics, bazaars, fairs, rodeos, and other events. There are 24-hour liquor and malt beverage permits for sales at meetings, conventions, private parties, and dinners. And retail liquor license holders and resort liquor license holders can get those 24-hour permits. There are malt beverage permits available to be able to sell malt beverages at public auditoriums, civic centers, and event centers. And there is a special permit for the Wyoming State Fair. And then finally, there is a new permit that the legislature enacted this past session for large rodeo events. I'm sure you're all familiar with that one as it received a lot of discussion during the last budget session. And so with that, Mr. Chairman, I'd be happy to answer any questions.
Yeah, go ahead, Chairman Lannon.
Thank you, Mr. Chairman. So Ted, thank you for all the work you did to help catch us up on all of these statutes and licenses. My question is, who we have in the restaurant license area, for example, a restaurant must prove that that 60% of its gross sales are for food only. Who polices that? Is that a Department of Audit issue, or is that our other department that oversees our liquor area? Where does that come from?
Is that a feel good in law, Mr. Hewitt?
Mr. Chairman, I might defer to the liquor division on that one. I'm not sure who polices that, the locals or the state.
Gotcha. I guess I have a question for you, Mr. Hewitt. In regards to the special permits, we did allow that large rodeo event to be in statute for a special permit. And one exists for the state fair, one exists for Laramie, one exists, and the list goes down. We've got all these mandated special permits. That what? Yeah, I guess how many special permits do we mandate in law total is there?
Mr. Chairman, it's these 6 that I ran through.
Okay.
Yeah.
Gotcha. Committee, any other questions for Mr. Hewitt in regards to his memorandum? Yep, Chairman Lannon, go ahead.
Well, thank you, Mr. Chairman. Just for the benefit of the committee and for me as specifically, I hope we can get into a little bit of a conversation about where we got into a situation of limited permits and thus the ability for the sale of those permits. I think approval was always necessary by the local jurisdiction, but we've seen where full liquor licenses have gone for a lot of money. And so I just want to make sure I understand how we got there and where we might want to go from here. Ted, I'm not sure if you have any comments on that or, where that might have escalated from, but I would appreciate any thoughts you have.
Mr. Hewitt.
Mr. Chairman, Senator Landon, certainly the prerogative of the committee to head in whatever direction it would like with respect to possible action in this area. I think the committee was interested in getting background on the existing statutory scheme for licenses and permits, and so where you go from here is up to you all.
Thank you, Mr. Chairman. Thank you, Ted. I'm not necessarily advocating that we make dramatic changes in how we operate. I just want to make sure that we all understand, where we were, where we came from, and where we are now. So, thank you.
I got Representative Duncan first, and then Senator Scott.
Thank you, Mr. Chairman. So, Ted, I don't know as far as a history lesson if you have this information at the ready, and maybe I need to reserve this for the Liquor Commission, but has it always been the decision at the local level giving the licenses to the local business, or has that come more recent in history? Did you find that? Because the reason why we're here today in the nexus of it is that some locals are doing it right and some are not. And some are using it as blackmail or, using it as a power struggle. So has it always been at the local level first, or has it, been at the state level in history at some point, or has it always been at the local level, I guess is my question.
Mr. Hewitt.
Thank you, Mr. Chairman. Representative Duncan. The short answer is I don't know. I didn't evaluate the statutes as they've changed through history. I was just looking at the current version of our statutory scheme.
Thank you. I appreciate it. Thank you.
Senator Scott, go ahead.
Yeah, Mr. Chairman, I'd like to know for those licenses where there's limited numbers and a formula for how many you can have, to what extent in those various categories are there unused licenses available? And I don't know whether that's a question for Mr. Hewitt or for the division or for Mr. Mosher. And I would also like to know, is the resort liquor license, does that have a limitation on the numbers, or does anybody who can meet those pretty high qualifications, can anybody get one?
Mr. Hewitt.
Mr. Chairman, Senator Scott, on the first question, I'm not aware of how many licenses are available at this point for any given category of licenses. On the resort licenses, I can pull up that statute.
Mr. Chairman?
Yeah, go ahead, Senator Case.
Mr. Chairman, the number of resort licenses is not limited in statute. It's a qualifying facility. I actually hold one of these licenses, or my company does. So it has to do with the number of hotel rooms, serving food, and having space for meetings.
Awesome. Senator Scott, any other questions?
No, Mr. Chairman, that answered my one question, and the other one, maybe one of the other outfits will know to what extent are their licenses that are available. I expect there are some in some of the communities in all the categories, but I don't know how widespread it is.
Gotcha. Any other questions for Mr. Hewitt? Yep, Senator Schuler, go ahead.
Thank you, Mr. Chairman. And this may be a question for the liquor folks too. I'm not sure. I know that there is a situation in some communities where, and particularly with COVID, I think we might be seeing more of this, where a business is shut down for a while And what they do is they park, it's called parking their liquor license. And I'm wondering what the requirements are, or if that's something we need to look at during the COVID issue. I think there's a certain amount of liquor that they still have to buy, but I'm interested in knowing if that's going to be kind of a high mark for some of these folks that may have shut down and maybe aren't back up and running again. So if that question could be answered sometime during this conversation, I'd appreciate it. Thanks.
Mr. Hewitt, do you want to take a stab at that one?
I will, Mr. Chairman. I'll defer that to the division.
Okay. Any further questions for LSO? Seeing none. Yeah, I guess no questions. I'm trying to figure out how we're going to get our arms around some of these issues. All right. Thank you very much, Mr. Hewitt. Really appreciate your time on that. At this time, we're going to go ahead and bring in, you can see on your agenda, we've got Mr. Mosier. He's the executive director with the Wyoming State Liquor Association.
I do not see Mr. Mosier on here.
I think he's with Mr. Montoya.
Okay, I will go ahead and admit him.
There you are. Mr. Montoya or Mr. Mosier, which one of you wanted to start out first? Mr. Montoya, you're with the liquor division, correct?
Mr. Chairman, that is correct. I am the Chief of Enforcement with the Liquor Division.
Gotcha. Why don't we go ahead and start with you, Mr. Montoya? Any kind of testimony you'd like to give, and then we'll let the committee ask questions.
Mr. Chairman, we've been listening to some of the questions on there, and basically these COVID questions. We had long discussions with the Attorney General's office. For instance, there is a minimum cap that microbreweries must brew, which is 50 barrels a year. The $2,000 purchase requirement for full retail licenses. And basically what we're doing at renewal when we review those, and we've talked with all the licensing authorities across the state, is that we're prorating those numbers. We're not going to ding anybody because they had to close during that time of COVID. It wasn't their fault. And so we're just adjusting those numbers to work with them as much as we possibly can.
And Mr. Chairman, Mike Mosier, Wyoming State Liquor Association, in addressing Senator Schuler's question, the same would be reflected in minimum purchasing or anything like that. Although minimum purchasing only applies to full retail licenses, the liquor division will look at that case by case. So I don't think we have any concerns about that.
Gotcha. Representative Duncan, you happened to miss both times your question was answered. Darn the luck. So
Sorry.
Representative Duncan, you had a question.
Yes. I have a question of one, why do we have minimum amounts for microbrews versus maximum amounts?
Mr. Chairman, if I may, once again, Mike Mosier. Actually, it's the minimum amounts were halved about 3 years ago. Okay. 50 barrels isn't a lot of beer, but the reason it's there, and it's standard across the country, is you don't want a home brewer calling themselves a microbrewery. You need to have a minimum production level to ensure that it's a bona fide business rather than just hobbyists looking to open up their garage. And so universally, as far as I know, within the microbrewery industry, they support the 50 barrels. We have it for them. I believe it was Senator Nicholas who brought out the bill. But if you go to minimum, you end up with hobbyists, and we don't really want that because that kind of misconstrues what the idea of a microbrewery is. With maximums, microbreweries have more leeway. They also are taxed differently on a national level. And so you don't want a large company, large brewery calling themselves a microbrewery. So that's what that cap is for, is to make sure that those benefits do not extend to larger breweries.
Follow up, Mr. Chairman.
Yep, go ahead, please.
Thank you, Mr. Chairman. So I have a scenario here where I have a local company that the city is trying to hold a company hostage with their license. So here we are that they've been mandatorily shut down, and we'll address this again in another bill later, but mandatorily being shut down during this COVID health order. And they don't sell food, so they weren't able to do anything like that. They were only could do growlers, so they had very limited audience, and so they were really limited on how much they could brew. And so the city, they're a quarter away from their quota that they have to meet in the year, and the city is already threatening them that they're not going to renew their license because they're not going to meet their quota of their brewing amount. So they are sitting there having a great relationship with the state. The state is willing to work with them, but it's the city that is holding them hostage. So that's the struggle that I have with this real division between one set of rules with the local municipalities, the counties, versus the state. The state seems to be working with these businesses and are business friendly, but our municipalities who are holding these licenses seem to have a different agenda and a different set of rules. So I have a question. How do we work on that? How does that compute with the liquor licenses and that total dysfunction between the two entities?
Go ahead.
Chairman?
Yeah.
Representative Duncan, that's a great question. And as you know, the way the licensing renewal process works is a licensee must turn it into their local authority, but the law requires they forward that immediately to the liquor division. And then we look at that. After discussion with the Attorney General's office, we are prorating, again, full retail licenses on the $2,000 purchase requirement, microbreweries on the production requirement. And if there's a licensing authority that is given a licensee a problem with that, we will definitely step in and let them know what the Attorney General's office and our office has said about it. We'll definitely work with the licensing authority to work on behalf of the licensee in a case like that.
I've got a follow up on that. Mr. Montoya, I mean, if this emergency situation that came about caused your agency to change their safety regulations because their safety regulations weren't rising to the occasion and were going to negatively impact businesses, wouldn't it be better for the state to permanently change its laws or regulations in regards to being something that be a little bit more flexible for businesses, not only because this could happen again, but because, I mean, safety regulations that are proven to actually impact businesses and have nothing to do with safety should be gotten rid of.
Well, Mr. Chairman, obviously this was a 100-year pandemic, and this occasion has never arisen. I've been here for 30 years and we've never had to deal with this type of a situation. So I guess really that's more of a question for the legislature, if that's what they wanted to do, you know, to build those kinds of things into law that would allow for these types of situations should they arise. We've never had to deal with this before, and that's why we've been trying to be absolutely as business friendly as possible, because we understand, you know, we see the reports. There's been quite a few licensees during the renewal that just aren't going to be renewing. We've seen a lot of relinquishments, especially in the restaurant license category, but they're running the gamut. We've seen some even with full retail licenses, which is somewhat surprising because those are the one license that does carry a value. So,
and Mr. Chairman, to address part of that concern with Senator Schuler's question, the debt revisions bill in front of you gets rid of the $2,000 because it is kind of silly to hold a full retail. $2,000, I know people who drink more than $2,000 a year.
Representative Duncan, any follow-ups?
Yes. Oh, am I open? Yes. Thank you, Mr. Chairman. So I hate to put you on the spot, but you just testified that you were doing, basically, you just said that you were doing, I'm just going to say it. You were doing what we're doing in the next bill without legislative permission, which is actually in violation of state statute. How do you feel about that? I mean, what's your response to that?
Mr. Chairman, Representative Duncan, again, we sought counsel from the Attorney General's office, and they felt that there was enough wiggle room, basically, so that we could, at least since the shutdown was no fault of any licensee, that they wouldn't have to meet those requirements, and that we could prorate those numbers to be as business friendly as we possibly could.
And to follow that up, Mr. Chairman and Representative Duncan, if we did do statutory changes, it would be too late unless we run it in a special session. So I appreciate what the Liquor Division's doing, because the need is immediate rather than for next legislative session. By then, hopefully, we'll never have experienced a situation like this again, I hope.
Representative Duncan, go ahead.
Thank you, Mr. Chairman. So, gentlemen, how do you feel about these, dealing with these? We're constantly getting bombarded by these local entities having these power struggles and using these liquor licenses as basically as weapons over our small businesses. How do you see that we fix this?
Mr. Chairman, Representative Duncan, I think it's unfortunate when that happens, but honestly, I hardly ever see it. And I think that does need dealt with. I'm just not sure if we need statutory changes for local problems, but with 99 municipalities, I could count on one hand the instances where the situation, and maybe Mr. Montoya can correct me, it's a very isolated case when a local licensing authority gets involved to that level of what you would call blackmail. I can't think of a time I've personally encountered it recently, and it sounds like you have, and that's unfortunate. We'll have to deal with that, and I'll work with Mr. Montoya, because that's not how it's supposed to work. Holding licenses as blackmail is not kosher, whether you address it in statute or not.
Mr. Chairman?
Go ahead, Representative Duncan.
Sorry, I'm bombarding you with all my questions. I've been holding them up for a year now. Also, I have another question. What about these zoning issues? We had a bill come over, I guess, 2019 that didn't go through. That was a municipality was holding liquor licenses based on zoning, that they were directing and shifting the bar, as you say, as I would say, for a business based on changing the bar and changing the movement of that particular business, of how they wanted things based, and they used the terms of the business. They were using it, and they were using the term zoning infringement and such for that neighborhood. And the infraction that they were using was zoning, and they were using their liquor license as the weapon per se.
Mr. Chairman,
go ahead.
Representative Duncan, you know, I've worked a lot over decades with city councils and county commissioners, and sometimes I don't agree with what they do, but I honor their ability to zone appropriately. And I realize there are cases in the city you're talking about that had the legislation. It sounds like there's one in your city. The one in the northwestern corner of the state, the business had changed, and they're good people, and I can understand the difficulties. I just get hesitant in changing state law because of one or two isolated municipal issues. Now, we supported the bill in 2019, but that being said, I really do support, like I said, even though I don't agree with them all the time, the right of local licensing authorities to determine, that would be city councils, county commissioners, to determine what's best for their community. Whether they want a bar within 4 blocks of a church or a packaged liquor store on the busiest street in town. I think it's important that they have that right to determine that. And I'm not sure how you legislate it without stepping on the toes of that ability to decide what's right.
Final question, Mr. Chairman.
Go ahead.
So do we need to do a better job of educating our local municipalities and the councils of these people who are making these decisions and who are deciding yes or no for and renewing these licenses that are being more business friendly? And because if they are good citizens and they have no infractions in these businesses, there shouldn't be a reason for them to be so anti-business and fighting with the locals. Should we be doing a better job of educating them? Because the testimony I heard from my locals was that they are getting such amazing service from the state, from you guys, and they're really headbutting from just a couple people in the local office who have never owned a business and who don't get it and understand. And so that's the frustration that I'm getting and I'm hearing from across the state, is that the state's doing a fantastic job, especially during this time, and they just don't understand that this person is just, it's one person who has a little bit of power and they're exerting it to the full extent locally. So are we just not doing a better job of educating locally? Can we do something?
Mr. Montoya.
Chairman?
Yep, go ahead.
Representative Duncan, great question. And we had a hard time getting on the agendas with the county commissioners and WHAM and WHAMCAT in the past, but the last few years, they've actually been very open to us. And we have been going in and we've been teaching them the law. We've been keeping them updated on the legislation year after year for about the last 4 years now. We are doing newsletters to the licensing authorities now as far as what has happened with the legislation. And we're talking to them on a daily basis. My two agents, they field, 50, 60 phone calls a day just from licensing authorities. And we're glad to talk to them and instruct them. We even have a lot of city attorneys now that are calling us and asking us how to work things. And we've even are helping with some of the municipal ordinances with them and at least reviewing them for them, make sure they're not in conflict with state statutes. So we're working on that. Are we there yet? No, we're not. But we are definitely working on that. And that's a great question. And we will continue to expand our education to the local licensing authorities and to the licensees as well.
Seeing no further follow-up, Senator Scott, go ahead.
Mr. Chairman, I just think we've got to be a little cautious here. I know one of the instances that did come to us in a previous session, it actually proved to be a local zoning problem where the business had grown into what was a zoning violation and was causing trouble for neighboring businesses. And the basic issue was parking. And the locals had you could agree with them or disagree with them, but they had a rational reason for what they were doing. So we can look at it. I have no idea what's going on in Goshen County, but we've got to use a little caution before we jump in, just based on anecdote, because sometimes there are disputes local where there's more than one side to it.
Do you agree, Mr. Montoya?
Mr. Chairman, I do. And one other thing, I know that Senator Scott had talked in the previous session with Mr. Hewitt, who did a really good job, by the way, is we do have a census report that we do on a monthly basis. And basically it looks at every single jurisdiction, all 122 of them in the state of Wyoming, and their population formula. And we'll be redoing the population formula once the 2020 numbers are in. But it'll give all the different types of licenses, the ones with all licenses, and how many are issued and how many are available. And I'd be happy to send that off to each member of the committee so they'll have those numbers.
And to tie into that, Mr. Chairman, that means new licenses, bar and grill and retail, will be authorized this year through the census report later this year. And so we'll find out how many. And to give you an idea, for example, bar and grill licenses, There are 80 in use and 211 authorized that aren't in use. And so in many cases, Laramie County has over 50, I believe, full retail liquor licenses that aren't used. So you might be surprised with the amount of licenses that are just laying around for somebody to take them. And undoubtedly after this pandemic, there's going to be a chunk more.
And maybe you already answered it. In regards to the 60% food sales, who monitors that?
Mr. Chairman, that is monitored by the local licensing authority, but we also look at that number. And if we raise an objection, we will do what's known as a correction memo to the licensing authority and ask them to look into it. And if it's something that we suspect even further, it could go all the way up to the Department of Audit, but usually it never does. Once we raise a concern at the state level, the numbers are usually corrected right away.
And usually, Mr. Chairman, when Mr. Montoya and I worked on the bar and grill license on the invention thereof, we ran the numbers, and the numbers were more like 90% food and 10% alcohol for restaurants. So it's usually not even close. It's not really a factor in the vast majority of places.
There have been some, though, that have come close.
Mr. Chairman, I don't know of any. I'm sure there have been a few, but I don't know of any that didn't reach the threshold.
Yeah, Mr. Chairman, to add on to that, where we see that is probably going to be in the resort areas, because you're going to pay high dollar for wines and spirits and stuff like that. It's not that they're selling so much more, it's just you're paying a lot more for it.
Can you explain real quick how that 60% is consumer safety?
Mr. Chairman, I wouldn't know if it's consumer safety. The 60/40 is to ensure that the focus of the business is on food service and not alcohol. As we go through the revisions bill, we'll find we're going to make a couple tweaks to how the restaurant dispensing areas, if you will, are defined. But with the bar and grill and restaurant, it's to ensure that their focus is being a restaurant first with alcohol as a sideline, rather than trying to be a bar in a restaurant suit. There is a public safety factor in the sense that bars and packaged liquor stores, a preponderance of them tend to be negative, have a deleterious effect on economic development, on drunk driving stats, stuff like that. Restaurants usually don't, and that's why there's a population formula. So restaurants aren't considered as much of a concern or challenge to law enforcement or anything like that.
Okay, Senator Case, sorry about that. Go ahead, Senator Case.
Thank you very much, Mr. Chairman. Well, just there's one point about alcohol and regulation and everything that's kind of in the big picture, and that, of course, there was prohibition in the United States, and then prohibition was repealed. But that very act of putting alcohol back on the table, it was done with this recognition of local licensing and states being able to regulate. And it is it's sort of like you have a constitutional right to most things, but alcohol and licensing, that's sort of an exception. So that's why there's a lot more regulation. There's freedom of speech issues as well, that you can regulate a liquor establishment with respect to freedom of speech, because it's all this constitutional stuff of it being prohibition and coming back in. And there's sort of this really important aspect of reopening the country to from prohibition, was that there was granting of power to local communities to decide what their community norms were, whether they wanted them or not, what kind of establishments, that the establishments had to be on good behavior. We have very vast different communities, and it seems very unfair if you're a liquor holder that you're in a community where maybe the predominant religion doesn't tolerate drinking. But that is part of this whole uneasy balance that we have with respect to alcohol in this country as a result of prohibition and coming back in. That's more of a comment, I realize, Mr. Chairman, and the boys down in Cheyenne can comment on that if they wish. But I do have a couple of specific questions with respect to something for the department. And Mr. Chairman, the first one is it seemed that there was another law that was sort of bent, and it involved open containers and allowing people to take alcohol from a business as part of the curbside thing where they didn't have a package license. And that one concerned me quite a bit as well. And I was wondering, again, was that another one where you bent the statutory authority? That's the first one. And the second one is another tool that the department has. It's a negative tool, is that you can require someone that hasn't paid their taxes with respect to the state, or maybe got behind on their taxes, which I think a lot of businesses did during COVID, especially like payroll taxes. But you can put a kind of a hold on their liquor sales. And then you can also go so far as to require like a cash to be able to sell liquor. Is there any relaxation of that particular policy? I bet a lot of businesses got in a little short-term trouble, and they probably got themselves straightened out by now. And I would wonder if the department's going to maintain that policy. I think you do it for a year. I wonder if there's any flexibility.
Mr. Chair, Senator Case, I'll catch door number 1, and I'll let the Liquor Division catch door number 2. The executive order issued by the governor for curbside for bar and grill and restaurant licenses, we actually worked on with the governor's office and with the Wyoming Lodging and Restaurant Association, and reached consensus that it was fair. We have members, and to clarify for those who don't know, Tom's the liquor cop for the state, and I'm the lobbyist that represents businesses that sell alcohol. We have restaurant members, club members, all of which were suffering. And so we felt the least we could do is extend a temporary help through an executive order or support one that the governor would issue to allow that temporarily. That expired, that EO expired on the 15th. And so it's no longer in effect. Once the bars and restaurants reopened, the EO expired that same day. So it was a temporary help. Lots of other states have done it. In fact, lots of other states went further than Wyoming did. But this was one of those times where, as an industry, and I got to give my board credit, everybody realized that everybody was hurting. Even the packaged liquor stores were doing okay. But we all knew that we had to help each other as much as we could to get through this, because a lot of us didn't. So we supported the executive order to do so. We're also happy it's gone, because technically, as Senator Case pointed out, it's kind of an open container issue in some cases, although admittedly, the way the executive order was written is it had to be in its sealed original container. But it was the only time that a restaurant or bar or grill could do that. Bear in mind, however, that if a restaurant had a full retail liquor license, they can also do delivery of closed containers. So this isn't a brand new concept, but it was a new concept for restaurants and bar and grills. And I salute the governor's office and the Lodging and Restaurant Association for working with us to find a good middle ground to help those businesses survive this. Tom?
Mr. Chairman,
Mr.
Senator
Montoya.
Chase, again, and Liquor Division was not part of that COVID team that made that decision and advised the governor. That was Mr. Mosier and the whole COVID team, Restaurant Lodging Association, those folks. So we just basically take advice from the executive order. As far as sales tax is concerned, we work very closely with our sister agency, the Excise Tax Division over at the Department of Revenue. And basically, if they're not making sales, they're not making taxes, but that doesn't necessarily mean they're behind as long as they're filing their reports, even if it's a zero report. But I do know that they do have an option for sales plans. So if somebody does get in arrears in sales tax, they'll often put them on a sales tax plan to allow the business to continue to operate. And they'll notify us immediately that they're on a sales tax plan, and we start selling to them to work as much with the licensee as we possibly can.
Follow up, Senator Case?
I'm going to take it privately, Mr. Chairman. I don't quite agree with it, but I'll figure it out.
Representative Duncan.
Thank you, Mr. Chairman. I don't know if you guys have the answer, but is the kind of the open container, I guess is what we'll call it, does the state of Louisiana have the same kind of policy as what we've been following? Because they kind of have an open container currently, don't they?
Mr.
Go ahead.
Chairman, Representative Duncan, I don't know if it's changed recently, but yes, Louisiana was one of the last states where you got to actually serve an open drink out a drive-up liquor window. We changed that law about 10, 12 years ago because you used to. We used to call them goers back when I owned a bar. But we're more responsible now. But I think unless Louisiana's changed, they allow something that I don't think anybody else does.
Mr. Chairman,
Go ahead.
I think as long as the straw paper is on the straw, the cocktail is considered covered. Yes?
Mr. Chairman,
Yeah,
not
go
in
ahead.
Wyoming. Not in Wyoming.
No, in Louisiana?
Oh, in Louisiana, it's possible. In
Yeah.
Wyoming, a full retail licensee can sell like a cocktail to go, but it has to be in a liquor division approved sealed container, which means vacuum sealed or something like that. It can't just be in a go cup with a paper straw over the top. So they do have options. They just can't go as far as Louisiana.
Last follow-up,
Go
Mr.
ahead.
Chairman. So is the vacuum sealed what you're saying that we were allowed during the pandemic?
Mr. Chairman, Representative Duncan, no. Those, if anybody drinks the little out of the little slushy machines in packaged liquor stores, that's what those are. They're sealed so the customer can't get inside. So essentially, it's like an unopened container. But problem is with a goer cup with a straw is you can just drink it as you drive away. If you tried that with one of those slushy things, it'd be a rather messy affair, I would think. So that's why we allow one thing, but we don't allow the other.
Thank you.
Senator Case really brought up a great point. If we suspended something due to the emergency, did we see an increase in DUI rates, or do we know any of the statistics in regards to that by suspending that or allowing for that to happen?
Mr. Chairman, I haven't seen any statistics on DUI rates. I do know that 911 calls were up for domestics. Liquor sales were up slightly during COVID. I was looking at those numbers just the other day, thinking that they would probably be down, and I compared them to 2019, and they were up slightly. And I'd be happy to share that information with the committee as well. But you have to look at it. In 2019, we were selling to over 1,300 licensees. In 2020, from February, March, April, May, we were only selling to around 600 licensees, and still we had a slight increase in the number of sales from the liquor division. So basically what that's telling us is that people were buying packaged liquor and taking it home and drinking. And we also noticed too that they're changing the way they drink. I know that the big beer companies, are very happy because beer has been on the decline for a number of years. And during COVID, they've actually increased. People are going back to the old standards. They're not buying the premiums. And this is where it's hurt somewhat the local businesses as far as the craft distilleries and the microbreweries, because they tend to be just a little bit pricier, and people were not drinking the premiums. They were taking the less expensive, but in larger quantities.
Well, I don't know if correlation is causation, but our business filings are also up in the state too. So liquor sales and business filing, people getting too many beers in there. And saying I'm going to make a go of it. No, and I guess I wasn't around in the legislature when the open container law was put in place, but I'm guessing that the reason for it was to curb DUI rates, to slow that down. And one of the interesting things is if you look at the DUI rates in the state of Wyoming, that really hasn't been the case. It's been an ineffective policy because realistically, people, instead of packing a beer in their cooler when they get off of lunch, instead of doing that, because that's illegal now, they're just stopping by the bar on their way home and having a beer or two with their coworkers. And as I don't spend much time at a bar myself, but when you're, when you're sitting around with friends at a bar, you're going to tend to stick around a little bit longer versus just sipping on a beer on the way home. Is there any thoughts on that you'd like to share, Mr. Montoya? That's kind of Mr. Motion.
Mr. Chairman, I think Mr. Montoya's been doing this long enough. He ain't touching that one.
Other than the fact, Mr. Chairman, if I go to the bar with Mr. Mosier, we don't stay long because he never buys.
The open container law, I don't think made much of an impact, Mr. Chairman, but I think it was mostly the idea of people pulling up to a drive-up window or driving with the beer between their legs. Obviously, drunk driving is the crime, and drinking a beer doesn't constitute drunk driving. But that being said, one of the things about drunk driving stats is bear in mind that Wyoming also drives more per capita than any other state in the country. So when you look at per capita DUIs, that's another factor. Obviously, it's a very serious problem, continues to be a serious problem, as does drug driving and distracted driving. But retailers have come a long ways. There's a number of cities, quite a few, who've instituted their own taxi services in working with the taxi, with law enforcement. And so I think we've come a long ways in reducing it. A lot of the DUIs you see are actually leaving from home rather than leaving from a bar. But we, with our alcohol server training program and the Tipsy Taxi, or whatever they're called in what city programs, I think we've come a long ways. But unfortunately, no matter how hard you try, you ain't fixing stupid. So there's still going to be people to do it.
Right. Senator Scott, go ahead.
There we go. Mr. Chairman, on the open container, when that was passed, the debate in the Senate, as I remember, particularly the sponsor was Senator Turner out of Teton County, law enforcement had been mightily offended by the way some of the people who were drinking and driving were doing so with open containers in the car and just flaunting them at the law enforcement. And there was an element of the lawbreakers were doing it just to show the cops they could. And I think they thought that it would be useful in terms of helping them enforce the DWI laws. And certainly, it's hard to say, but it looks like we've had a long-term secular decline in the amount of serious drinking and driving accidents and the death rate from it. So how much the open container contributed to that, I don't know, but it looks like it's done some good.
Further questions for Mr. Montoya or Mr. Mosier? Representative Duncan.
Thank you, Mr. Chairman. Going back to the stats of the standard beer versus the micro brews or the higher specialty brews, do you think that has to do with sometimes more the fact that some of your specialty brews are being consumed in the brewery versus the at home?
Mr. Chairman, Representative Duncan, very good point. Actually, we have a tips program, as I've probably talked about, although we work with the liquor division. We've trained over 36,000 people in a nationally certified class on alcohol service. And part of it is educating your customers on the proof of things. Problem is, back in the day, all whiskey was 80 proof, all beer was about 3 to 4%, so about half an ounce of alcohol. But with micros now, and don't get me wrong, I love micros. I drink them, I celebrate them, they're my friends, but some of them can catch you off guard unless you're aware of the ABV, the amount of alcohol in it. Mm-hmm. And so you've got some stouts, for example, or that will go up to, or Scotch ales, et cetera, that will go up to 20, 30 proof. And so one of the things we talk about with microbreweries, and the ones I've seen are very good at this, is letting your customers know, this isn't Bud Light here. This is about 6 Bud Lights. And so that's a large onus onto us. And there's other factors as well. I mean, with wines have been going up in proof as well. So you've got some wines whose ABV is approaching that of like schnapps. And so that's part of our job as retailers, is to educate our customers to know that this stuff can catch them off guard, because a beer is not necessarily beer, wine is not necessarily wine, and that's on us to a large extent. Now, unfortunately, customers at home, we can't control that, but that is a factor, Representative Duncan, and good question. That's a burden that we are working our best to make sure people know about.
Follow up.
Go ahead.
Thank you, Mr. Chairman. So your stats might be skewed slightly because they may be drinking. So your stats show that those crafts and craft drinks are lower, but that was my question. Was the fact that your stats are showing that the big companies are those stats are up higher than your craft numbers?
Mr. Chairman, Representative Duncan, correct. A lot of the craft product is drank on premise. And that's why, they were still able to sell off premise, but those sales diminished compared to what they were doing when they were running both on and off premise. But because of COVID, they couldn't do the on premise. Right. And that really decreased it. I mean, people love to go and hang around the local microbreweries. I know there's a few of them here in Cheyenne. And, on a Friday night in the summertime, you'll see they're just absolutely packed. And it's a lot of fun. They weren't able to do that. And so, yeah, that's a big cause for the diminishment. And same thing goes for the manufacturers as far as craft distilleries. They couldn't go into the satellite craft distilleries. So, yeah, they could still sell package. The liquor division does still sell some of their stuff. But when you shut down the on-premise, it really did dig into their sales.
And traditionally, if I may tie in, Mr. Chairman, during recessionary times, people's alcohol consumption doesn't go down, but it gets cheaper. And microbreweries, like micro distilleries and specialty wines, are more expensive. So Joe would rather have 3 PBRs for the same price as six. And so I know that guy. I've had beer with him. So that's one of the factors that drives what Mr. Montoya is talking about. If you lose your job, you're not going to drink less. Hopefully you won't drink more, but you do drink cheaper.
Okay. Yeah, I guess one last little deal. We allow for wine deliveries to the home. I'm guessing we allow beer deliveries to the home? No, we don't.
Mr. Chairman, we don't. We allow wine because we had to. It wasn't allowed in statute to begin with, but after the Granholm case at the Supreme Court, we were allowing out-of-state direct shippers to license with us and sell wine. So we corrected that in statute to be in compliance with the Supreme Court case to allow Wyoming wineries to direct ship, but breweries, no. Microbreweries, no. They have the ability to deliver through wholesalers, so they can still deliver across the state to retail stores.
And Mr. Chairman, to tie into that, I think Granholm was in 2005. We legalized direct shipment of wine from out of state in the late 90s. Spirits and malt beverages are not included in that. But that's the same is true with most states. Most states do not allow the direct shipment of spirits. It's seen as a higher risk for underage in particular. For example, a frat house ordering a case of whiskey, the difference between the proof of beer and spirits is high enough. And as we'll talk about perhaps a little bit with kegs are no longer the drink of choice for underage people, it's spirits. And so there's not too many underage people drinking $40 bottles of Merlot, but our fear is with spirits, and like I said, it's echoed across the country, that there is that concern for spirits. And
Mr.
so
Mosher, isn't there a requirement to check IDs though?
Mr. Chairman, they're supposed to, although we have really weak common carrier language for wine delivery. And we would like to, and I talked about this when we passed the bill last year, or when you passed the bill last year, to modify the common carrier for nicotine products. I think eventually we need to firm up our common carrier language for wine delivery in Title 12.
Maybe add spirits and malt beverages to it also, is what you're saying?
Mr. Chairman, I'm not sure about spirits. Malt beverages, You almost got me. But some states have. I'm just saying that most people don't really need or want that. The one advantage with spirits and with the liquor division is you can order, a packaged liquor store can order any product on the planet through the liquor division through the special order process. So it's not really needed, but we can certainly, I wouldn't want to see it in this bill, but we could certainly discuss it down the road.
Further questions for Mr. Moser or Mr. Montoya? Representative Duncan, go ahead.
So just to clarify, you just said that I could special order spirits or malt beverage, but I can't, yes, no?
Mr. Chairman, Representative Duncan, retailers can special order spirits, any spirit or wine known to mankind. You can order direct ship wine. So, you know, if there's a California winery and there's a wine that the liquor division doesn't list, you can order it directly from that winery. We actually increased those amounts. You could do it about 3 years ago,
Right.
4 years ago, I believe it was Representative Hunt's bill. So special wine delivery, allowing out-of-state wine delivery is pretty common across the United States. But with spirits, there's just a handful of states that allow it, to my knowledge.
Mr. Chairman.
Go ahead.
However, I can join a wine club, but I get kicked out and the state prevents my wine after so many bottles. It doesn't, it stops after so many bottles get delivered to my home, correct?
4 cases.
Mr. Chairman or Representative Duncan, yes, 4 cases. Now, admittedly, you could order that from the individual winery. If you found a wine you liked, you could order 4 cases from them, which would last most people for a while. But there is a cap on that, as there is in most states.
Mr. Chairman.
Go ahead.
So if I'm at a place and if I'm at a distillery and I'm vacationing and I order some, they'll ship it home, but I can't be at home and ask them to ship it to me, correct?
Mr. Chairman?
Go ahead.
Incorrect. Shipment of spirits and malt beverages is prohibited in Title 12. So you could bring it in, you could carry it in if you wanted to bring a few bottles with you, or if it's over a certain quantity, as long as you pay the excise taxes and you carry it in, you could do that. You just couldn't have it shipped.
Mr. Chairman, so I'm on vacation and I'm in Kentucky and I buy a bottle and they cannot mail it home for me?
Mr. Chairman, Representative Duncan, that is correct. First of all, you couldn't mail, period, because it's not allowed through the mail. But UPS, FedEx, one of those common carriers, no, not in Wyoming. It's prohibited for malt beverages and spirits.
And Mr. Chairman, Representative Duncan, as I mentioned, it is in most states. Kentucky in particular, I think you get shot if you try it. Most states, or a lot of states, especially in the South, the penalties are pretty severe for any attempt to direct ship spirits. There's just a completely different mood regarding that product.
Okay, thank you.
Further questions? Any further questions? Seeing none, Mr. Montoya and Mr. Moser, please hang out because you might be drugged back. I think now we're going to go to Mr. Noble with the Department of Revenue. He should be joining now. Director Noble. Can you hear us, Director?
Thank you, Mr. Chairman. Yeah. Can you hear me?
Yeah, yes, we can hear you, Director.
Okay, thank you, Mr. Chairman. Mr. Chairman, members of the committee, I'm Dan Noble, Director of the Department of Revenue. I really am just here to answer. Hello?
Yeah, we can hear you, Director.
All right.
Also, I believe, Director, that you've got YouTube playing in the background. So if you could silence or just turn that off so that we're not getting that feedback.
I just turned it off. Is that better?
Yes, sir. Thank you.
Okay. I wanted to chime in mainly to talk a little bit about, some of the questions that have been raised about the regulatory framework that's been established in Wyoming. And I think it's kind of important to recognize why it even exists. What we've been doing since 1933, when Prohibition was repealed, is attempting to regulate a product that has potential negative issues for the consumer. It isn't, what do we say? We're not selling Twinkies here. This is a product that does have harmful effects in some instances. And the federal government, when they repealed Prohibition, basically put the onus on the states to actually regulate this product. And every state has a very different way of approaching that. It's been something that has been a conundrum for a lot of years for every state. Wyoming is considered a control state because we actually engage in one aspect of the sale of the product, and that's at the wholesale level. There are states that are involved in retail as well. The state of Utah has retail establishments, so that's probably, and Idaho as well. So it's real important to understand that it's kind of unique the way that we approach it, but it is not something that every state doesn't regulate in some way, shape, or form. There are states that are considered open states or licensed states where there are jurisdictions within those states that are completely dry. They do not allow the sale of alcohol, period. One of the classic examples is Lynchburg, Tennessee, where Jack Daniels is made. That's a dry county. Kind of a contradiction in terms, if you ask me, but it is something that is creates issues for every state. What little is known about it is that there are 88,000 deaths a year associated with this product in one way, shape, or form, either through drunk driving, illnesses created by the product itself. There's a number of issues that are faced by the states, and that's probably why it's regulated. It does potentially have harms associated with it. The bill or draft, I should say, that is being proposed is really just kind of a cleanup of some of the, I guess I'd call arcane language associated with Title 12. And I believe that Mr. Montoya and Mr. Mosier have worked quite a bit to try to address some of these cleanup issues. And I'll certainly turn it back over to them, but I'll answer any questions you may have from my perspective on this as well.
Questions for Director Noble? Seeing none.
Okay.
Thank you, Director Noble.
Certainly.
Committee, we are going to go to public comment. Actually, I don't know if we've got any public comment waiting on this. LSO, Jill, can you?
We do not.
Gotcha. Thank you. All right, so we don't have any public comment. Mr. Montoya and Mr. Mosier, do you want to take one last stab before we close public comment?
Mr. Chairman, would you like to address the revisions draft or carry that over to the next meeting?
No, that's a good idea. Let's go ahead and address that now.
Because with your permission, Mr. Chairman, we can zip through it pretty fast. As Mr. Noble mentioned, much of it is cleanup. Just real quickly, I just wanted to mention that part of the reason I'm pushing back a little bit on any major changes is estimates are nationally that 1 out of 4 restaurants will go out of business due to the COVID pandemic. In Wyoming, since our shutdowns weren't as bad or as long, I still expect a bit of a bloodbath, to be perfectly honest. We have 1,400, just short of 1,400 retailers in this state. And if we don't lose at least 100 businesses through this process, I'll frankly be stunned. I salute the governor and appreciate what he's done and know the necessity of what was done. but it isn't going to change the fact between the COVID pandemic and the economic downturn in minerals. This is probably the most difficult time we've seen in the industry since Prohibition. And so I just wanted to get that point out. With bars, clubs, and restaurants, I think it's been particularly hard. Manufacturers such as distilleries, microbreweries, wineries, some have done okay because they can still sell their product. But some businesses have been completely shut down. And so the good thing about this bill, and I'll start zipping through it, Mr. Chairman, is it doesn't hurt anybody, and I don't see any controversy in it. This is like a scratch sheet that the Liquor Division and I have done for the last 3 years since we passed the series of bills. I believe there were 4 through corporations back in 2017. So most of this is just cleanup. So if you would like, Mr. Chairman, we can just zip through the bill page by page really quick.
That'd be great.
Okay, thank you, Mr. Chairman. On page 1, it's fine. Turn to page 2. What page 1 does is add definitions that we had defined in Title 12, but we didn't list in the beginning of the statute. So this is just adding stuff we already had. The only addition is on page 2 under T. We did this a while ago. So there should be a U under that includes the malt beverage permits for events conducted at rodeo arenas, which is the bill that was passed this last session. If you look further down there, the building shall have a dining room or rooms, a kitchen, etc. We're deleting that because it makes it clear that the restaurant definition needs to be a restaurant, but the excessive language is very hard to define, and it's been all over the board. We've got fast food burrito places who've been given bar and grill licenses. We have places that are really nice that have bar and grill licenses that had to put a burrito on the menu because that's what it took to become full service. And so that language is problematic, and it's really up to the local licensing authority, as it properly should be, to be defined in that. So we just delete that language because it's really unneeded, and it's going to be defined by the local licensing authority anyway.
In the middle of page 2, under Mr. Chairman, under 12.2.201, the wholesale licenses, there are basically 2 licenses that a microbrewery can obtain to distribute their beer. And it's a redundancy. One basically just allows them, and this is the one we're deleting, allows them to purchase a license, and then they can sell their beer to a licensed malt beverage wholesaler. The microbreweries a number of years ago went to the legislature and said, we want to be our own wholesalers. And so the wholesale license basically will allow them to do the same thing. So it's really a redundant license. So, and I think there's only 2 that use it now, and they could definitely switch to the wholesale license and do exactly what they're doing. So there really isn't a need for it. It's just an archaic piece of language.
Is there a cost difference there, Director?
Mr. Chairman, it's $50 difference, so it's minimum.
Gotcha. Please continue.
Okay, on page 3, you did that. Okay. On page 3, repeal 12.2.501 through 12.2.505. A little over 15 years ago, we adopted keg registration, which sounded spiffy. It requires the Liquor Division to pay for, and bear in mind, anything the Liquor Division pays for doesn't go into the general fund, but pay for keg tags, registration information, etc., that retailers used every time they sold a keg. Unfortunately, and I think Mr. Montoya would agree, I've never heard of a single case in those 15 years where anybody's actually used keg registration for the purposes of law enforcement. Part of the reason is because, as I mentioned in earlier testimony, the drink of choice is not kegs anymore. I unfortunately harken back to my age in the days, of course, I didn't partake of keggers. Now spirits is the choice, and most people who buy kegs are people of age that like microbrews and stuff. And so that language, we're just taking out. It saves the Liquor Division money. It hasn't been used, and it saves our retailers labor. Now, some of them will still voluntarily continue to do it as they did before that point, but it takes that out. Okay, the site and zoning, is that yours? Oh, wait, one more. Under 12.4.101A, the stricken language. That's just a housekeeping. When we passed Senate File 43 in 2017 and changed some of the formulas, including unlimited restaurant license, et cetera, this should have came out. We just didn't see it.
On, Mr. Chairman, on page 3 in the middle there, 124102, that's a requirement on the application that they
I'm going
have
to jump in real quick, Director. Representative Duncan has a question. Go ahead, Representative Duncan.
Thank you, Mr. Chairman. As you approach 124102, I noticed, and maybe it's just an oversight, when you get to that right above that correction there on number 7, you probably needed to strike out "and shall contain the following provisions." Just a notice.
Noted.
Maybe remember that if this is picked up as an amendment to the draft. Thank you, Representative. Please continue, Director.
Yeah, again, Mr. Chairman, basically what this does is the site and zoning has to be put on the application. The state does not use that for anything. That's really a local issue. Most licensees really don't know it, and they go to the licensing authority. So we just want to clean up the application. If there's a site or zoning issue, that's between the licensee and the local authority. The state doesn't get involved in site or zoning issues. So it's not needed on the application itself.
Next page.
The 124103, basically what that does is over the years, the legislature has allowed the dual holding of a microbrewery or winery permit with other licenses. So you can hold a microbrewery and a restaurant license or a retail license, resort license, bar and grill license. And it was never put into statute because this is a restriction under 124103 that says you can only issue one permit. The licensing authority can only issue one permit to any holder of a license. So this just allows what is being done and has been done for a number of years. It was just an oversight that needs to be corrected.
Next page, deleted language at the top of the page. Senator Schuler asked about this $2,000 minimum purchase. $2,000 is so ridiculously low for those of us who drink, especially Mr. Montoya, because he drinks really good stuff. And if you order one case of decent wine a month, you're at $2,000. So it's easy to get to. It doesn't need to be tracked, and the rest of it is redundant language as well. Further down under 124104, the stricken language, place the notice conspicuously upon the premises shown on the application as a proposed place of sale. That's when they come through and paste your liquor license renewal on the wall. Well, they do it online now. Very few municipalities and counties actually go from place to place and paste them on the wall anymore. So we just strike that language so they can use the same technique they did before. If you turn to the next page, page 5, removed language claiming renewal preference is stricken. That's because we got rid of that language in 2017. We just missed this reference to renewal preference. Lastly, before I kick it over, I think to Mr. Montoya, 124409 is restaurant license language about transfers and stuff. Well, in 2017, we made restaurant licenses available on an unlimited basis. So it doesn't matter if you transfer it or not. Nobody really cares because if you don't, you just get a new one. 124410 was the, oh, that was
restaurant.
Okay. Restaurants are still required to have a dispensing room. Problem is in some cases, it's got to be floor to ceiling. So sometimes it can be problematic and it's kind of difficult to do. And so what the stricken language does is basically makes it so the alcohol needs to be prepared in an area, but you don't need floor to ceiling. You don't need anything like that. The concern, and a lot of retailers are concerned about it, we don't want restaurants pretending they're bars, but if you flip to the next page on page 6, it says no restaurant liquor license shall promote or operate, that's added language, the restaurant as a bar and lounge. Also, I would propose, and this was from the prior paragraph in stricken language, to add, and no consumption of alcoholic or malt beverages shall be permitted within the dispensing area. We don't want bars to run into that, or restaurants to run into that 60/40 problem, but we also want to make it easier for businesses and licensing authorities to do this. So it really doesn't change anything legally, it just changes it logistically. So Tom and his folks don't need to come into this restaurant that has a wall up here and a dispensing area back there and say, no, you need to put sticks up there because it needs to be a wall. This just makes it a little more reasonable and a little easier to enforce.
The next thing, Mr. Chairman, 124412, and this is really the crux of this bill and why it's lengthy, is basically microbrewery and winery law have been written in together. And it's incredibly confusing. It's been confusing for the licensees. It's been very confusing for licensing authorities. And to be honest, it's been confusing for myself and the staff here at the Liquor Division. So basically all we're doing is we're just pulling microbrewery and winery apart because they don't distribute the same way. They're completely different types of licenses. So we're just pulling them apart in statute so that it's an easier read and easier to follow, especially for general citizens and licensees. We're not changing the law other than on page 8 under section 6. And it's something that we forgot to do a number of years ago, is add bar and grill. If you remember, I told you just a few minutes ago that you can hold in conjunction a microbrewery license and a retail, restaurant, resort. We forgot to put bar and grill in there, and that's what that does. It just adds bar and grill. Other than that, there are no changes, and that goes clear through page 10 where we start 12.4.14, and that's where we add winery back in. That we pulled it out of 4.12 and we're putting it back into 4.14, and we're just putting it in. We're not making any changes in the law.
And to explain why that happened, Mr. Chairman, we did microbrewery and winery law back in the 90s, and we didn't think there'd be that many, so we just lumped them together. But that shows how great profits we are. Obviously, they've grown more popular. With distilleries, that's got its own section in law because we only did that about 10 years ago. So that's got its own section. What this does is separate the confusion. There are no changes legally except the little tweak about bar and grills that Mr. Montoya mentioned. So there's no controversy. We're just making it easier by splitting those two sections apart. Let's see.
12.6. Yeah, 12.6.101, that is a cleanup in language from the 2017 revisions bill. Again, we used the word "an establishment," and that's created a lot of confusion. We're getting a lot of convenience stores, big box stores, and saying, well, they can't come into our establishment. That's not what that meant. It meant within that area. So all we're doing is we're just cleaning up the language. We're not changing the law. And we're just spelling it out to the designated sales area approved by the licensing authority. But it's not changing the law. It just makes it more clear.
Lastly, 12.9.102, that's the malt beverage wholesaler franchise law. I will be brief as I can, and I will be brief, I promise. Mr. Montoya mentioned Granholm versus Heald. That was a Supreme Court case back in 2005. Granholm was a Democratic governor from Michigan, not to be confused with Lindholm, who was a Republican legislator from Wyoming. What that said is you have to reciprocate your laws. If you allowed Joe to do this in your state, he's got to do it in out of state too, and vice versa. And as Mr. Montoya mentioned, we did corrective legislation on that. Well, last year we had something even bigger, and that would be the Tennessee Wine and Spirits Retailers Association versus Thomas. That was last year, and that brought up the Dormant Commerce Clause. It was a kind of a silly premise that the Supreme Court case came under. If you think Wyoming's liquor laws are silly, look at some other states. Tennessee had a law, believe it or not, that you only had to be a resident for 1 year to have a liquor license, but to renew it, you had to be a resident for 10 years. And the renewal is annual, so there's a bit of a problem there. So it turned out to be a lawsuit. Well, the Supreme Court case went a lot wider, and it brought up the Dormant Commerce Clause in saying everybody needs to be treated the same, wholesalers, out of state, in state. There were exceptions like public safety, that states can set their own liquor laws. But when it comes to interstate commerce, it's pretty much the same. There's a lot of states that are running some serious problems with this, whether it's lawsuits or statutory challenges. After scanning Title 12, unfortunately having to scan Title 12, I only saw one example that would be a potential lawsuit, at least to me, and I have others that agree, in Wyoming statute, and that's 129102. What that does is it basically creates a statutory monopoly franchise law for malt beverage wholesalers. Now, this isn't as big as it sounds because it's already self-imposed by the breweries. But on the other hand, with this in statute, I see it as a potential legal challenge. Will it be a big deal in Wyoming? No, but we're a cheap date when it comes to wanting to set a precedent. And so this statute, I think removing it doesn't hurt anybody. Actually helps everybody a little bit. As the good senator from Fremont County knows, if a retailer wants to get a specific malt beverage product and they can't get it from the local wholesaler because he refuses to carry it, you literally can't get it. Whereas with the liquor division, you can special order everything. So this would give the option of a retailer that wants a product, malt beverage product, that their malt beverage wholesaler won't get, to get it. However, as I mentioned, number one, I think it's unenforceable anyway, but number two, it's all self-imposed by the breweries. And in that sense, I don't consider it being good in statute just because of the potential litigation route that it opens up for the state. I hope that was somewhat cognizant and a good explanation. And if not, don't blame me because I'm just a layperson, and you can have Senator Nethercott explain it if you want something more eloquent. Other than that, that is our bill. It's fairly simple. Like I said, there are a couple tweaks we would like to make if it is adopted by the committee. I would like to keep it non-controversial. These are just fix-its to help people do their job a little easier, whether it's cities, counties, retailers, whatever. And I believe we'll stand for any questions, Mr. Chairman.
Mr. Mosier, you want to keep it non-controversial, but there's amendments. You might not know of them yet, but Senator Bear, go ahead.
You call me,
okay.
Mr. Chairman.
More fun that way, Mr. Chairman.
Yep, go ahead, Representative Bear.
Thank you, Mr. Chairman. I want to go back to the section on 12.4.10. We're calling this just a cleanup bill, but it seems like this section actually is a policy change where it makes the separation of the area where liquor is prepared and sold. With this provision in there, it makes it separate from the other business that the entity carries on. And with this restriction, it seems like we're eliminating that separation. Am I understanding that correctly, or is that not right?
Mr.
That would seem
Chairman,
to me, and that would seem to me to be a policy change, not just a cleanup.
Mr. Mosier.
Mr. Chairman, Representative Bear, I appreciate your concern, and it's a very good question. Admittedly, and that's why I suggested adding a little more language, it may go further than what the legislature feels comfortable with. And if there's a middle ground, we certainly would be open to it. We do not want restaurants operating like bars. We just wanted to make the definition simpler and make it so instead of having a full wall, you could do a half wall, any kind of partition. So Representative Bear, I wouldn't be opposed to any modifications that would find a middle ground that would make the legislature feel more comfortable.
Further questions, committee? Senator Scott, go ahead.
There we go, Mr. Chairman. Not a question, just I would like to compliment Mr. Mosier and all gentlemen. Excellent legislative drafting job. I'm sure we'll talk about some of the details and there may be amendments, but I just wanted to compliment you on helping us out and doing some of the hard work of simplifying some of these things. Legislature spent a lot of time in other areas, and I think you've saved us quite a bit of time. So appreciate it.
Thank you.
Thank you.
Completely agree. Yeah, absolutely. Any other questions for the Division of Liquor or Mr. Mosier with the Liquor Association? I'm not seeing any. I'm going to call on Director Noble. Director Noble, do you have any comments or anything like that in regards to the proposed legislation?
I think probably the area that was pointed out in 12.4.410 is a policy issue. It is something that I think is important, mainly because when you look at how it's actually implemented, I'm not sure that it really is relevant in today's society. You put up a separate dispensing room, and quite frankly, it doesn't necessarily change the dynamic of how the restaurant operates. It doesn't really offer a huge change in the way that product is delivered, because obviously it's delivered to a table, and seeing how it is prepared is probably something that some people actually prefer to see anyway. Especially in today's society, you may very well want to see exactly what's going into your drink. So I think it's something that is probably, I would consider to be arcane language in itself, and but it is a change in policy, and certainly needs that level of scrutiny, because it is something that is not just a cleanup issue. It is a change in policy. The other area that I think you probably need to get some other discussion and opinions on is the 12.9.102, the issue associated with the franchise laws that are currently out there for malt beverages. Certainly has the potential of having issues with the Tennessee ruling, but it is also something that deserves some level of scrutiny to make sure that we're comfortable with it. And you probably need to hear from the malt and beverage folks to see how they feel about it. I think it's real important that they weigh in on this as well. And with that, I'll stand for any questions you may have of me.
Questions for Director Noble? Not seeing any. Thank you, Director Noble.
Sure.
And on the points that Director Noble brought up in regards to hearing from different organizations, because this isn't an official draft or anything like that, our legislation, if we decide to move this forward, we'll have to get officially drafted, and we'll be seeing this in another committee meeting where I'm sure there'll be more amendments brought and what have you. So that's a possibility of kind of drawing everybody in, and pieces of legislation always do a really good job of drawing people in to talk to us. So that's one benefit if you choose to move this legislation forward. Is there any? Yeah, Representative Clifford, go ahead.
Thank you. Can you hear me okay? You can hear me? Okay, good. On page 4, I just have a question as far as the 12.4.104, the publication of notices. Is this an either or, whether we have to publish in the newspaper when there's a permit renewal or a transfer, and then it identifies the county and then the city? So is that an either or is that or both, whether you do use the newspaper or you use a social website to announce, publish that notice? I just need a clarification on that one.
Mr. Chairman?
Yeah, go ahead, Director.
The publication is still required in a local newspaper for 2 consecutive weeks. That doesn't change. The only thing that this modification does is that there's a requirement that the local licensing authority has to physically go to each bar and each restaurant, each private club, resort, whatever. And they've got to post a notice on the door that says they're going to be renewing the application. Most don't do it anymore because they have websites. I mean, this is a very, very old law. And so now they can do it on the website, and just to let the general public know that there's going to be a public hearing if they want to show up at the local, either at City Council or Board of County Commissioners hearing. So if they've got any comments or objections to that license, they can then voice their opinion, and that's all that does.
And Mr. Chairman, to give you an idea of the number, I mean, for example, there's a couple municipalities in Wyoming, Representative Clifford, there's a number of a couple of municipalities in Wyoming that have 80 to 90 different businesses they have to go pin stuff up on if they're going to do it. So it's a rather cumbersome process. And as Mr. Montoya mentioned, it's really not followed anyway.
Mr. Chairman?
Go ahead, follow up.
Thank you. Thank you for the answer, and thank you for all your work. I have another on page 6 under 12.4.10, but it's on page 6. This is the first I've seen of under D. No restaurant liquor licenses shall promote or operate the restaurant as a bar and lounge. Is lounge equal to a grill? Is that the same thing? This is the first I've seen. I read through all of this, and the first I've seen lounge, and then looking at the LSO draft and learning this. Is that the same as a grill?
Mr. Chairman, Representative Clifford, that's an absolutely wonderful question because I used to operate a lounge, which was a bar, and actually it's probably interchangeable. You could probably strike the term lounge because it's a bit obsolescent and there's no real legal definition of it. Lounge is what old people call it, like me, but bars are what younger people call it. So good catch. I'm not, yeah, like I said, I don't know if it needs lounge in there.
Further questions? Seeing none, I guess kind of an unrelated question I have, is there a prohibition against places like gas stations from having a malt beverage license or having a full retail liquor license in the state of Wyoming?
Mr. Chairman, no, there are a lot of gas stations, C-stores all across the state that have them. It just depends on what the local are willing to issue licenses and what kind of businesses they want them at. For instance, in Cheyenne, most people thought, well, grocery stores can't have liquor licenses. Well, that's just not true. There's grocery stores all over the state that have liquor licenses. It's just the city council for a number of years didn't allow it. Now they do, but it's really just a local option, what they want within their communities.
And Mr. Chairman, that's usually driven by concern about underage access. The idea that with a liquor store, you could spot under 21s looking for third-party sales easier than you can spot it in a C-store or grocery store. We really don't take sides on that one. I can understand the discussion on both sides, but as Mr. Montoya mentioned, I know one city in the center of the state that has at least 4 grocery stores or big box stores with liquor licenses, several convenience stores. So it's actually pretty common.
Representative Duncan.
Thank you, Mr. Chairman. So this dialogue sparked a couple questions. So going back to some history, why do we limit liquor licenses for population? Can you give me a history on that?
Mr. Chairman, Representative Duncan, well, we do want to end before noon, so I'll try to be fast. But most states regulate the number of licenses. For full retail, we have unlimited access to certain licenses such as restaurant, but there's a number of economic studies, and I didn't bring any of them with me, but I'm glad to look them up in my hard drive. But a number of economic studies and also law enforcement studies that show that proliferation of full retail liquor licenses, i.e. bars and packaged liquor stores, lead to problems with, as I mentioned, both law enforcement and economic development. So those are usually regulated. There are a lot more states that are a lot more restrictive than Wyoming. We're actually pretty wide open. And since we came up with the bar and grill, we're more wide open than many. So that's traditional. It was instituted originally in 1935 with the full retail license. Since then, the restaurant license, the limited retail club license, the bar and grill license, the resort license, those have all been added since that period of time, most of them in the last 30 or 40 years. And that's really made up in a large sense for any supposed shortage. But to give you an idea, I believe the DOR looked at it a couple of years ago. There's more liquor licenses per capita in Wyoming than there is in Colorado. We have a lot of liquor licenses. And sadly, as I mentioned before, I think you're going to see a lot of liquor licenses come available for all the wrong reasons, because it's not going to be good out there. So that's historical, Representative Duncan. It's been that way since 35, and we voluntarily tweaked the formula with barn grill licenses. We've tweaked the population formula twice, I think, since they were invented, if you will, 13, 14 years ago. And we're happy to continue to look at it. I don't know if this is the year, since we have the census coming out, so there'll be new licenses. And with the condition that the industry's in right now, busting loose a bunch of licenses with the businesses in the pain they're in is sort of like seeing your neighbor drowning in a lake and swimming out and putting an anchor around his neck. So we're open to it. We will continue to be open to it, but that's the history, and I hope that summed it up well.
Mr. Moser, it seems like the exact opposite, that now would be the time to look at it, considering you're going to have a bunch of liquor licenses open up, thus should drive down the exorbitant cost that these government licenses are being sold for. It seems like now would be the time that we get rid of this silliness that Wyoming is guilty of. Senator Scott, go ahead.
Mr. Chairman, let me answer that question a little more bluntly than Mr. Mosier did. The licenses, retail liquor licenses, have had major cash value, been a major asset for important business people in the community. We have, in the past, mostly it's been the past 40 years. When I came in, it was still very restrictive. I remember my first speaker was Warren Morton, made a big project of loosening it up a little bit. And we have gradually eroded it and made licenses much more available. But by doing it gradually over time, we didn't destroy the finances of anybody who had invested in a liquor license and used that as a major part of their net worth and assets, and something people had worked very hard for. And that has been successful. We've gotten a much greater variety of restaurants and bars and grills and resorts and whatnot, so that people can get into the business, and that we can meet the needs of our tourist industry and the populace wanting to have more options without destroying anybody financially. And I think that's been a much more successful strategy than just abolishing it. And I think some of that still holds. So I think if you tried to abolish it, you would find some opposition from within your constituency that might be quite considerable. So it is a matter of judgment. But that's, I think, one of the principal reasons that it would destroy some people economically. Probably not so much anymore, but it would still, I think, hurt people quite a bit. So it's the process we've used has been a gradual erosion and a compromise, and it seems to have worked.
I think that was a nod towards more gradual erosion. Representative Duncan, did you have a question?
Mr. Chairman, we can certainly look at it down the road, whether it's this year or later. But as I mentioned before, I think unfortunately there's going to be lots of licenses coming available. Unfortunately, we won't know the total casualty among licensees until probably next spring, because the problem is a lot of businesses with their liquor licenses, when they go out of business, it just doesn't go back to the local licensing authority. It waits until renewal time. So we really won't know the casualty count for a while. But I really appreciate this opportunity to testify to the committee. It's a wonderful committee, and we appreciate all the excellent questions and commentary.
Representative Duncan, did you have a question?
Mr. Chairman, I would like to go back to my original question. As far as the history, Mr. Mosier and Mr. Montoya, the history of the licensing going from at the state level or the local level in terms of authority. Do you know for the Wyoming in terms of history of the licensing authority has it always been at the local level, or was it originally at the state level? Can you answer that for me?
Mr. Chairman, Representative Duncan, it's always been at the local level. You know, in 1935, the legislature said we have a really big state and we have a diverse population and our towns are so far apart. And so, you know, local authorities, local elected officials, they know their towns better than anybody else or their counties. And so it's always been a local control thing in Wyoming.
And Mr. Chairman, Representative Duncan, I think the point that was brought up before about some communities choosing not to let big box stores or grocery stores or convenience stores have alcohol, have liquor stores, but some do. You know, what fits Star Valley is not going to fit Cheyenne, is not going to fit Jackson. And so, like I said, I approve of local control. I don't always agree with it, but I respect their right to make sometimes what I consider silly decisions.
Seeing no further questions, I'm going to go ahead and close. And we don't have anybody waiting in the wings for public comment. So I'm just going to go ahead and close things up as far as public comment. Committee, what's your pleasure? Senator Scott, go ahead.
Mr. Chairman, I always seem to have a battle getting unmuted.
Doing great, Senator.
I move that we continue this to a future meeting and ask it be drafted as a formal LSO bill draft. And that the meeting that we take it up at next be at the discretion of the chairman.
Second. Second by Representative Blackburn. Discussions on the draft. Senator Case, go ahead.
Mr. Chairman, I just want to note for the record that I am president of a corporation that holds a resort liquor license in Lander, Wyoming. And I always like to declare conflict on liquor bills. I'm happy to discuss them. And I think we're basically moving in the right direction here. But I just wanted everybody and everybody out there in TV land to know that. Thank you, sir.
Thank you, Senator Case. Chairman Landon, go ahead.
Mr. Chairman, thank you. And I always appreciate Senator Case on issues like this because we really value the input from somebody on the front lines. Mr. Chairman, I think this is a friendly amendment, but I would hope that staff would include, there were two separate suggested additions to this, to these revisions. And I would hope that we would draft those in as if we choose to move this forward.
Mr. Hewitt.
Really, Mr. Chairman, we've got those additions down. I have add in a subparagraph U to include the permit for 7,500 person or greater rodeo events. And then I think on page 6 in that subsection D, add in a bit of language regarding where alcoholic beverages can be consumed. Those are the two additions that I have down.
Is the bringer of the motion, Senator Scott, are you acceptable to those changes?
Sure.
Mr. Chairman.
Hang on a sec, please. Representative Blackburn, you were the second. Are you acceptable to those changes?
I'm good, Mr. Chairman.
Thank you. Representative Duncan, go ahead.
Thank you, Mr. Chairman. And also, Ted, on page 3, section 12.4.102, I mentioned that section, the strike through of and shall contain the following positions,
Mr.
provisions, that needed to be strike through as well.
Chairman,
Representative Blackburn, go ahead.
Mr. Chairman, that change is not needed because there's like 5 other items above that. So we still need to have that.
Yeah, that's right.
Mr. Mosier, do you agree?
Yes, Mr. Chairman. I think both Mr. Montoya and I agree that there are Romanettes 1 through 6 above that that would need to be continued to be included in the provisions.
Gotcha.
Thank you, Mr. Chairman. Never mind. I stand corrected.
Representative Duncan trying to strike out more law. I like it. Any other discussion on the motion by Senator Scott and second by Representative Blackburn to draft this into formal legislation to be seen at our next available meeting? Seeing none. And I'm just going to do a hand raise on this. All those in favor, please raise your hand. Oh, those opposed, please raise your hand. Motion carries. Okay, so we'll be seeing that as a draft piece of legislation. Committee, is there any other legislation you would like to see in this regard? I guess if I could really quick, one of the reasons why we took up this issue had to do with these special events, and whether or not we as a committee want to take action on that is definitely up to you. But the reality is, as we go through, we're going to keep seeing these types of legislation. And while we might be at 6 special events, have a special exemption in law right now, perhaps we should nip that in the bud right now. But I don't know. That's up to you, committee. Any thoughts on that?
Mr. Chairman?
Yeah, go ahead, Representative Duncan.
In the time in the space that we're in with our revenue decline, and I'll just throw it out there, it's very controversial, but I really have a problem. If you go to your local grocery store and you ask for the exemption book, it's that thick. So I really have a problem with every time you turn around, we have exemption after exemption after exemption. So I think in the spirit of that we have 6 special exemptions. I think we need to have that conversation, whether we're for or against the exemption here. I think it's going to keep coming back as what you just said. So I'm not saying whether I'm for or against, that situation, but we have 6 special permits. So in essence, it's an exemption. So we need to have this conversation because it's going to continue to happen. So we definitely, I think, need to dive into that because it's going to continue. That's all I really need to say.
Senator Scott, go ahead.
Mr. Chairman, we're skating always with these special exemptions of risk of violating the constitutional provision against special and local laws. But I haven't frankly been able to figure out a way to write a general statute that would accommodate what we really need to do. And, like the state fair, we really need that exemption. And it's the same is true of the other ones. So if somebody has a stroke of genius, I think we should welcome it and look at that particular issue to see if we can set some general principles where the liquor division or somebody like that could issue these. But I haven't figured out a way to do it that works. Yeah,
it's a tough cookie. I mean, I think we all agree that we'd like to get rid of these special exemptions. But at the same stroke, you're going to have to write something in the law that states must issue based on X factors and shall be, we don't want a situation where we're revisiting this because now a malt beverage license is going for $100,000 again. Mr. Mosier or Mr. Montoya, any thoughts on this? Actually, before I go to you, I'm sorry, Representative Ayer, go ahead.
Thank you, Mr. Chairman. I just had the thought, and it's kind of a moot point currently, and I don't know when the situation will change, but right now we have no special events.
It's a good point. Definitely not a pressing need. Hopefully it will be soon. Mr. Mosier or Mr. Montoya, any thoughts?
Mr. Chairman, I agree with looking at all permits and licensees. I think it's a continual process. However, I have to agree with Representative Ayer. It's kind of a moot point right now, so maybe this is a good time to look at them, but we can always look at the idea of streamlining or making things easier. Obviously, things like catering permits are an extension of existing liquor licenses, so they're nothing really special in that sense, but I don't mind taking a look at it. So we can do that informally and just take a look and see what we can do and see if it's worthy of something for the committee to pick up.
Representative Duncan, go ahead.
Thank you, Mr. Chairman. What about the situation of, can you do a yearly catering permit versus per event? Is that something that we could streamline and do something along those lines? Because I've heard some horror stories in that scenario too. Is there a flat fee that we could do for approve one of these venues, one of these, licensees, that they could do a one time a year, permit?
Mr. Chairman or Representative Duncan, you're allowed quite a few catering permits because that's per site. The limit is per site rather than a total number of catering permits. But I kind of like the idea, and the people of municipalities are going to send me flowers for all the nice things I'm saying about them here. But overall, municipalities, I like the idea of them looking at each event to decide if it's being run correctly, if it's monitored correctly, if they have the proper things in place. And so my concern is with a statewide permit is essentially you're opening another liquor license. And so at that point, you might as well have it. So I would tend to favor the event by event process currently in place with cities and counties just because of that greater control.
Senator Scott.
Mr. Chairman, what I would suggest is that if Mr. Mosier, with or without Mr. Montoya, can come up with some things that will simplify life and make it easier for existing and new businesses to do business without doing great harm, if we can find some further simplifications that are a little more policy issues than what's contained in this bill, which is properly limited. That is something the committee ought to welcome. And if the industry can come forth with some proposals just to make life easier and make business easier, given the hard times we're going to have for a while, that would be a very good thing. And we ought to welcome him at the next meeting or a year from now, depending on how long it takes them to get a consensus on some things. But I think that would be a very useful thing if they could do that.
I think Senator Scott is inviting you to be a little more controversial, Mr. Mosier, in your bill drafts. Senator Schuler.
Thank you, Mr. Chairman. I agree with Mr. Mosier for the most part. If you look at those special permits, only 3 of those have the wording of shall, and it's the University of Wyoming, the KEG permit, the State Fair Board, and the special permit for more than 7,500. I don't consider those problematic, but what I think we need to do is really leave the other 3 alone, because it gives the cities and towns and counties the option to take a look at their special events and make the decisions based on what's happened maybe in the past. We have one big event here, which has obviously been canceled this summer, but it's an event that's had some issues here and there, and they've done a really good job each year of trying to take care of some of those issues. A lot of them from out of state folks, not our Wyoming people. But anyway, it just seems to me that the special permits that we have right now are serving the purpose we need them to serve. I really like leaving them the way they are. But if somebody else has a great idea, if Mr. Mosier or the State Liquor Commission has something that they can come up with, a blanket, statement that'll take care of it. But really, I think we're okay where we are. Thank you.
And I think we're under a bigger, broader topic, right? Also, I mean, correct me if I'm wrong, Senator Scott, but your request of Mr. Mosier would be to look at all regulations that can be construed to be limiting to private businesses, and possibly bring forward some suggestions. Is that correct, Senator Scott?
Well, that's something we ought to do generally as a legislature. I think the charge here has to do with particularly with the liquor and the beer and wine businesses. But I think we would have good, as a legislature, should have good receptivity to proposals from the industry to get rid of Mickey Mouse stuff that really isn't doing anybody any good and is just costing the businesses money. I think that's in everybody's interest. And some of those are a little more controversial. I think they've quite properly limited the bill draft that's before us to the things that really are non-controversial. And what I'm hoping is that by going a step or two into things that might be a little controversial, that we can simplify life so the businesses can give people better service, so the population can enjoy things that they want to enjoy without being unnecessarily hassled and without having to pay for a lot of extra unneeded regulation. And this is the time, if Mr. Mosher's members have things that are just bugging them that just don't make any sense, this is a good time to get rid of them. And maybe there aren't any, but I'd be surprised.
Gotcha. Mr. Co-Chairman, are you all right with that request from Mr. Mosher to have him report on some other ideas in regards to being more business friendly for liquor licenses?
Mr. Co-Chairman, I think that's a great idea. And I appreciate the wisdom of Senator Scott, the suggestion that the bill that we just sent forward to the next meeting really stand by itself. And then anything that we might discuss in our fall meeting that we would want to take forward, I think let's go to round 2 and see if there aren't some things we can find. I saw in the national news today that we aren't going to have any police forces anymore, and so that might change some things. Things are looking. We could have lots of special events, every street corner. So, thank you, Mr. Chairman.
Representative Clem, go ahead.
Yeah, thank you, Mr. Chairman. Just a little bit of history, or if someone has the information, looking at those special permits, particularly the one for the University of Wyoming and State Fair. And of course, we passed the one last year for really what was Frontier Days. I'm concerned about the University of Wyoming and State Fair exemption in particular. It seems like that constitutes special legislation. Of course, I haven't really looked at the language more clearly, but clearly the intent is to single out those particular things. So I don't know, is there any history on that? Has that ever been challenged? I'm generally not in favor of expanding access to alcohol. That being said, this seems to be unfair as far as these exemptions. It shouldn't seem that if we're going to have such exemptions, they should be broader than just those narrow little niches. So any information would be helpful. Thank you.
Senator Scott.
Mr. Chairman, some of those, particularly university and state fair and whatnot, those are parts of the state government, and we can tell them very specifically what to do and what not to. We had to do the Frontier Days one a little broader than just something that would apply to just that operation to stay out of constitutional trouble. I'd love to see a more general principle on it, but I can't figure out how to draft it. But the history is, yes, we could be specific with people like the university and the state fair, very specific, because they are part of the state government that we can run the state government.
Representative Clem.
No follow-up. That was a good explanation. Thank you.
That's why I love having Senator Scott around. He's been around for all of this. Mr. Hewitt, go ahead.
Thank you, Mr. Chairman. I just want to note that I'm taking a look at the sections for the UW permit and the state fair permit, and it doesn't look like there's any case law relevant to those sections.
Thank you. Any further comments or discussions? Mr. Mosier, are you all right with that request from the committee to report back to us at our next meeting, which will hopefully be in person, in regards to finding some efficiencies in liquor law?
Mr. Chairman, I'd be happy to. I can't guarantee board approval by then because it depends on what, but we can kick out some ideas. And I'm more than happy at the request of the committee to sharpen my crayons and get a new Big Chief tablet and go hard to work.
Awesome. All right. I think that committee, do you have any other comments, discussions, motions, anything like that in regards to liquor licenses? I'm not seeing anybody raise their hand, so we're going to go ahead and close that topic. We've got a piece of legislation that we'll be looking at during the next go around in that. Committee, we're still ahead of schedule. It's 11:23. We were planning on taking lunch at noon and being back in at 1:30. Instead, we're going to take lunch now and be back in at 1 o'clock to give ourselves a little breathing room this afternoon. Those are kind of some controversial topics, so that we might stretch our legs on that. Either way, though, I really appreciate everybody's hard work. So we're going to go ahead and recess for lunch until 1 o'clock. You have an hour and a half for lunch. Pretty nice little lunch. So we'll see everybody then. And please remember to turn off your video and to mute your microphone during the lunch recess. Thank you.